everybody. We're glad that you are all here again with us today. It is session 9, so we've all been together for a couple weeks. If you only really do homeowner rehab and that's your only job and this is your first time joining us during these sessions, thanks for being with us this afternoon. My name is Chris Richmond and I work for ICF, and I'm joined by Les Warner and also Monty Frank, whose name is not on there. So Les is going to be my co-trainer today, and then Monty is going to be answering questions and sharing his deep program knowledge and wisdom and experience. So you'll hear a little bit from Monty as we go along today as well. So just to remind folks where we are, we have been doing this for a number of weeks. Today is the last of our homeowner series, so we're doing homeowner rehab. On Thursday will be our last session of rental. We'll be doing the long-term rental compliance. We're going to refer back to a couple of these other sessions, so if you did miss any of them, I know the first 4 are actually posted on the HUD Exchange. They're working to get the other ones posted as soon as possible. We do need to have transcripts written, and they have to be 508 compliant, so sometimes it takes a little longer than we anticipate to get them up. But I do know that understanding monitoring, program oversight, CHODOs, and oversight of program partners are all posted. So if you did miss those, you are able to go back and take a look at those. And really appreciate the investment and time that you're taking today for this training. So today we're going to talk about how HUD will monitor PJs for compliance and the requirements for homeowner rehab, or you might hear us refer to as owner-occupied rehab. So we use those terms interchangeably. We're going to be telling you, what do you need to know about homeowner rehab monitoring, and what is HUD going to monitor you? What are they going to be looking at? What do they expect to see in your files? If you're working with program partners, what do you expect to see in their files? We're going to be reviewing the monitoring handbook, so we're looking at Exhibit 7-26, and we're really going to be going over what are the requirements and what are the policies and procedures you have to have in place. If you've been with us along all these different sessions, you'll have heard the 3 of us refer to the policies and procedures a lot. HUD is really focusing on the policies and procedures. They want to make sure that you have complete and adequate and compliant policies and procedures. So you'll hear us reference that quite a bit. We're going to go over what the required documentation is to show that you've actually met compliance, so what needs to be in your file. And then we're going to look at program design considerations for homeowner rehab. So beyond the requirements, but what are some additional policies that the PJ might want to consider in its program design to ensure that their homeowner rehab program is compliant and that it's running smoothly. And then we're going to end our session by going over some recommended steps that you can follow to help get ready for your HUD monitoring. There might be a couple different acronyms that you may or may not be familiar with. We use the term PJ a lot. That's just participating jurisdiction. That's the entity that's receiving the home funds directly from HUD, so either a state or a state or a city or a local government or a county. We'll use the term IDIF. That's the Integrated Disbursement Information System. That's where you set up your projects and do your drawdowns and do all your reporting in IDIF. We'll refer to CPD and the CPD notices. So CPD is Community Planning and Development. That's the office at HUD. And then there's a lot of notices that come out, so we'll refer to the CPD notices. And then the home rule is at 24 CFR 92, and you might hear us refer to 24 CFR 200. That's the Uniform Administrative Requirements for federal grants. So those replaced all the OMB circulars and the 84 and the A1822 and the 83 about 4 or 5 years ago. So you'll hear us refer to 2 CFR 200 as well. So the requirements we're going to talk about today apply to the entity that's administering the homeowner rehab program. So this might be the PJ, it might be the subrecipient, it could be a state recipient, or it could be a contractor. But regardless of which entity administers the program has to comply with the home requirements that we're going to discuss today. And if you're working with a partner, you do need to ensure that they're following the homeowner rehab requirements. That's what we're going to talk about today. But you should also go back to the sessions that we did on April 22nd, the oversight of program partners and written agreements. Let me go back and show you that one. Where is it? Right here, April 22nd. So if you have a partner that's running your homeowner rehab program, go and you missed this session that we did on April 22nd, go back and listen to that, because that's going to be also important for you to follow, to be able to do the oversight and make sure that your partner is in compliance as well. And you would use Exhibit 734, 35, and 36 for monitoring your partner. So let's take a minute so that you can tell us a little bit about you. If you could answer one of the options and push submit so we know who's joining us today, that's really helpful for us to see. If we were all together in a classroom, I'd say raise your hand, but since I can't see you, if you could just go ahead, and there should be a poll that showed up on the right-hand side of your screen. If you could just click how many years of home monitoring do you have with the homeowner rehab program, that's really helpful for Les and Monty and I to get a sense of who's with us today. So go ahead and pick the one that's most applicable to you so we can see who's with us. So Medora, are we able to see the results? All right, so it looks like we have about 1/3 that's less than a year, so we have a couple newbies, and then the rest is split between 1 to 5 years and over 5 years. If you are super brand new, we highly recommend that you go to the self-paced online building home training. We do have a slide about this at the very end, so if you need a lot more in-depth information, that's a good resource for you to go to. We do consider this a more advanced training, so we're not going to go into great detail about the requirements. We do expect there to be some level of knowledge about homeowner rehab program, but please feel free, everybody, to go into the Q&A box when you do have questions about the content, to go in and write what your questions are, because we are going to try to answer as many of those today as we can. So let's talk about the regulatory basis for the homeowner rehab requirements. So in the Home Final Rule, Section 92-254 contains the core requirements related to home ownership. And then Sections B and C relate specifically to homeowner rehab provisions. And specifically, they address the maximum property values of the homes that the PJ can assist. Remember, we're assisting modest housing. It also covers the principal residency requirement for the owner. And then also, we're going to discuss the ownership interest. So what form of ownership must the owner have in order to be eligible for a home-funded homeowner rehab program. And then there's a lot of other regulatory references in the home rule that apply to homeowner rehab. So the PJ has to comply with all of these. So generally, these are other requirements that are related to ensuring that the participants are low income, that the costs are eligible, that the costs are reasonable, that the property is decent, safe, and sanitary at the end of completion, and that the PJ is following the home administrative requirements. And the exhibit we're reviewing today, 7-26, includes questions on all of these different requirements. And then the PJ needs to successfully implement and document compliance with each of these. So we'll go through what these are. So the CPP Monitoring Handbook includes each of the exhibits that HUD uses to monitor its programs. HUD refers to these exhibits. I might flip once in a while and refer to them as a checklist, but if I say checklist, I mean the same thing as the exhibit. So this picture shows 7-26. This is the one for homeowner rehab. This was also, we have the link for this at the very end. You can get to it from the HUD Exchange. It is housed on HUD Clips. So the exhibit is 30 pages long, and it has 47 questions. And these questions address how the PJ administers its program, whether the PJ has specific policies and procedures that are required by these regulations, and whether the project files have documentation that shows the PJ has complied with all the home requirements. And then you'll see on our slides as we go through today. And let's see if I can put a different color in here to show you. So I'm highlighting this in yellow at the top. You'll see as we go through the slides, there'll be question numbers at the top of each slide. And so these are the slides, these are the numbers that reference back to Exhibit 7-26. So it'll tell you, oh, this is question number 5, or oh, we're talking about question number 22. So you can go back later and check on the exhibit to find out more information about that question. We're not going to have these questions go in numerical order. We are actually going to be following how a program or a project is implemented, but you can reference back now that you have the question number on these slides to go back and look at the actual exhibit. Right, so this slide lays out how the topics are organized. So we grouped the 47 questions and we put them into 3 subgroups. So the first group, the marketing and participant selection group. This is the marketing to find the applicants, selecting your owners to assist, and helping to determine eligibility. Then we're going to look at the property and the project selection. So we're going to determine if the property is eligible for assistance. And then we're going to look at administrative requirements, and these are the mechanics of providing the home assistance through your homeowner rehab program. So these are all the different regulatory requirements. And then, after we review the regulatory requirements, we're going to talk about program design. So to run an effective homeowner rehab program, there's many policies that the PJ needs to establish that are not actually requirements. So this may define how the PJ will target home assistance, and it should reflect its specific decisions for how it's going to administer its local program. So we'll spend some time after we go through the regulatory requirements going through program design. So let's walk through each of the requirements, and we're going to identify what the requirement is, identify specific policies and procedures that are required, and identify what documentation you need in your file to show compliance, to show that you actually met that requirement. So as we proceed through each of the topic areas, we will not address each question, but we're going to summarize it in these 3 different categories. So we're going to talk about requirements. So we're just going to give you a quick summary so you know enough of what that question actually means. We're going to talk about the documentation. This is what needs to be in the file so that you can actually prove that it happened. And then sometimes we have a section called the compliance review, and this is really a judgment that HUD would need to make based upon looking at these things, what that compliance, whether it met it or not. And so these headings can also be identified by the colors that you see in the slide. So we'll have the requirements in orange and the documentation in green, and if applicable, the compliance review, that'll all be in blue. So if you've been with us through the last couple of weeks, this is still the same as all the other webinars. So first we'll take a look at the specific requirements that apply during the marketing and participation selection stage of the rehab process. So together, they make up all the required steps that a PJ has to take to determine if an owner is eligible. So both the owner and the property has to be evaluated before the PJ makes a commitment of home funds, and these should be documented in the file of the review of the PJ or the PJ's partner. So let's look at marketing and participation selection. So first we're going to start with affirmative marketing. So the PJ has to adopt an affirmative marketing plan, and the goal of that plan is to ensure that those least likely to apply know about the benefits of the homeowner rehab program, and that those least likely to apply are also able to apply for and access these opportunities that are being made available by the PJ through its homeowner rehab program. So what's the documentation? You would have a copy of the PJ's affirmative marketing policy. You would have documentation of any outreach activities. So if we were in normal times, right, we would have in-person housing fairs, community meetings. We're going to start to get to more normal times, I'm hoping, in the next couple of months. So as these things start to happen, as you start to have community meetings and housing fairs, you want to have documentation that these actually took place and put these in the file as well. And then the documentation should be showing the steps that the PJ's plan were being followed. And I do want to show you over here, if you are responsible If you're monitoring for compliance with affirmative marketing and the record keeping and the data compilation, you're going to be using Exhibit 22-3, the Guide for Review of Civil Rights, and that'll help you look through and see what needs to be determined for the compliance of the data. So let's talk about income determination. All home-assisted households must have incomes that are at or below 80% of area median income at the point of assistance. And so for homeowner rehab, the point of assistance is when the household is approved to receive assistance. And this has to be done within 6 months of when the household receives assistance. So you need to choose a definition. In the home program, we have the Section 8 Part 5 definition, or the IRS 1040. You need to choose one of these definitions to be used throughout your program. And then there needs to be the determination of the household income. So we're doing this calculation based on the current income and any anticipated expected changes in the income. And this could be raises, it could be overtime. So we're looking at anticipated income. We're not basing this on an average of past year's earnings. So that's really important for you to understand that we are looking at anticipated income. We also need to make sure that we have identified all the household members, because income is based upon household size. We want to have how many household members are going to be residing in the house or the unit, and then we're going to verify with source documentation. And what do we mean by source documentation? Well, on our next slide here, we have some information about source documentation. This could be your pay stubs, unemployment compensation statements, statement from another income-based program, maybe SSI. So that's what I mean by source documentation. And we have to have 2 months of source documentation in the file. We also need to have a copy of the application. And so the application, this is where we're going to find out the household size, and also what they list as their income. We are going to take other steps to determine that income, but that's a starting point for us. We will also want to have in the file a worksheet or an analysis, or if you're using the income calculator, the CPD income calculator, it's on the HUD Exchange, you want to have that printout. This is going to show that the household income was determined correctly, to have that type of analysis in there. And then for all projects, we need to make sure that we're using the same definition of income. So did you decide to use the Section 8 Part 5 or using the IRS 1040, making sure that the same definition of income is being used for all of the projects for your homeowner rehab program. And then for the compliance review, again, we're checking to make sure that the household size was compared with the income limits. The income limits are published yearly, and the income limits were recently published a couple weeks ago, and they will be put into effect in June. And then we also want to make sure that we looked at anticipated income, that all the household members were counted, and that the analysis was done within 6 months of funding commitment. So we do want to make sure that this was done currently. If more than 6 months has passed from you doing their income review and then that household receiving assistance, we would need to do the income determination again. So we want to make sure that that timing is being met. So now let's look at specific requirements that apply during the project review and selection stage of the process. So we're going to focus on the requirements related to the property and its eligibility for home assistance. And the PJ must ensure a unit or the home complies with these requirements before it commits to providing home assistance. So eligible form of ownership. So before committing home funds to a project, the PJ has to verify that the property is actually owned by the applicant. And the applicant, there's a number of different forms of ownership. The most common form we see is fee simple title. This is the most common one. PJs may run into a number of other ownership situations, and this list provides approved forms of ownership for the home program. So you might run into some of these other forms of ownership. So for properties with complicated ownership issues, such as inherited property with multiple owners who might not reside in the property, or life estates, or inter vivos trusts, or beneficiary deeds, the Home Rule provides guidance at 92-254C about these other types of ownership, but the key thing is to determine whether the occupant is low income and are they living in the home as their principal residence. So the PJ's file must contain a copy of the title search or a recent search of records for the property. So we need to have these, this title search or the record search documentation of that in the file. We do want to let you know that a copy of the deed alone is not sufficient documentation. So the property must be the owner's principal residence. And for the documentation, there's a couple different ways this can be documented. The most common I see is the owner self-certification. So many PJs require having the owner attest to this being their principal residency. Sometimes it's in the application, sometimes it's a separate form that's signed. Other PJs may use utility records or tax records to ensure that the household, that the name in the utility records, the tax records match the household's application. And the PJ's policies and procedures should specify how the PJ is going to document principal residency in their policies and procedures. How are they going to meet this? Are they going to do owner certification? Are they going to be checking these different kinds of records? This needs to be identified in the PJ's policies and procedures for them to be able to meet compliance. So all of the requirements have to be met before the PJ can make a commitment of home funds. And the PJ can impose additional requirements to tailor its program to meet local needs. So any type of housing is eligible in the homeowner rehab as long as the property is considered single family, and in the home program we call single family 1 to 4 units, or it's a cooperative, and this would be in a state where cooperative is identified as ownership. There are some states where cooperative is identified as rental. So if you live in a state where it's considered rental, you would not be able to use a cooperative property for homeowner rehab. But if you're in a state where it's considered ownership, then it would be eligible, as well as condominiums. So single family, cooperatives, or condominiums are eligible types of housing that you can use for your homeowner rehab program. You do have to be checking to make sure that the after rehab value of the home is less than or equal to 95% of the median purchase price. And the PJ can identify this in 2 different ways. Most PJs use the HUD-issued value limits to determine the 95% of median purchase price. These value limits are published by HUD. But if the PJ doesn't think that the HUD limits represent their local market area, they can conduct their own market analysis, but it must be submitted to HUD. It has to be approved by HUD before it can be implemented. So you're either using the HUD issued limits or you're doing your own market analysis. But again, that has to be submitted to HUD and approved in advance before being able to use. You also need to be meeting the environmental review compliance or any site-specific requirements. If you need to look more at environmental review, you can check out Exhibit 21-1. So for the homeowner rehab program, there might be a program-wide release of funds and a Tier 2 review for specific properties, but the project cannot move forward until this process has been completed. So for documentation, the file has to document that the property complies with each of these property requirements. And in your policies and procedures, you're going to identify which method did you use to determine the after rehab value. And again, this is done before we're committing home funds. We're not determining the after rehab value after rehab. We're determining it before we've done any work on the property. We're trying to determine, is this property actually eligible, because remember we want to use modest housing for our homeowner rehab program. So 3 different ways the PJ can determine this. They should choose one and put it in their policies and procedures and follow it. Most common we see is an appraisal. So you have a work write-up. The work write-up is handed to an appraiser, and the appraiser does an appraisal based upon what would the value be if this work was conducted. So that's the most common, so you would see a copy of their appraisal in the file. Or you could decide to do an estimate of value by qualified PJ staff. So your staff would need to have to understand the value that may be added to a property after rehab that had been conducted, so that's another method that could be used. Or a tax assessment could be used, but it's looking at the market value of comparable post-rehab units. So any of these three methods are eligible through the HOME program. You need to decide which one you're going to use, and that should be in your policies and procedures, and then documentation to support that needs to be in the policies and procedures as well. Needs to be in the file. So then we need to show that the value limits, so we have to have a copy of those value limits for that particular year that we're trying to determine that we're not exceeding those value limits. If you did do your own analysis, there needs to be evidence in your program files of what the methodology was followed, that it was published in your action plan, and there's evidence that it was approved by HUD. And then for environmental review, this RE, that stands for responsible entity. So for environmental reviews, you need to have a responsible entity's copy of the request for release of funds, and then any evidence of compliance of property-specific requirements. And then if the property is in a floodplain, we need to have a copy of the flood insurance. I do want to note that a program may decide to limit assistance and not provide assistance in a flood zone area or a floodplain area. Or they may decide we are going to do work in a floodplain area and we're going to elevate the unit along with maybe providing protection of systems such as the HVAC system for future damage. So that's up to your program design, but if you do decide that you are funding properties in a floodplain, you do need to have a copy of the flood insurance in the file. So the PJ has to adopt written rehab standards, and the written rehab standards, those detail the methods and the materials and the requirements that the home must meet upon completion. And the standards must include certain elements as listed in 92-251, and it must incorporate any applicable local and state codes or national rehab standard. It also has to address health and safety concerns. It needs to incorporate lead-based paint as well as accessibility requirements. We also need to be looking at our useful life of major systems. And so what do we mean by major systems? So a major system is a structural support, it's roofing, cladding and weatherproofing, plumbing, electrical, heating, ventilation, and air conditioning. That's what I mean by a major system, right? So major systems must be replaced if the remaining useful life is less than 5 years. So this has to be part of the rehab write-up. If it's not going to last more than 5 years, then it has to be replaced. A PJ can adopt stricter standards. Maybe they want to have a useful life of 8 years of major systems, or a PJ can set system-specific standards. So maybe they've set a standard where the HVAC system has to have a 10-year useful life. So this would all be decided in your property standards, what your useful life of major systems would be. And then the PJ must have an inspection policy. So at a minimum, the inspection policy has these 3 different parts. So first is the pre-rehab. That's your initial inspection to identify what the deficiencies are, and this is what's necessary for you to develop that scope of work. And then we need to have interim inspections. This is where typically they're tied to draws or invoice requests. So as you go through, or you want to make sure that the work was done, that it's meeting the standards. And then we need to have a final inspection, and this final inspection is ensuring that it's met everything in the work write-up and it's met all of the rehab standards and the state and local codes as well. And then you do need to ensure that your inspector is meeting their minimum requirements, that they've had proper training, that they understand the property standards and construction practices. And then we have this property standards tool, the same tool that we've had throughout the sessions. So let's get to this one. So we're looking at rehab. I'm scrolling down a little bit. You may need to scroll down as well using that gray box. So for rehab, we've listed the different property standards here for rehab and what the documentation is as well. So it's another resource you can go back and look as well. This is one of the handouts that was provided to you in the link where you found the training slides as well. All right, so to document your property standards, I've been talking about these policies. You need to check the policies to make sure it identifies what the written rehab standards are, as well as the inspection policy. And then for each project, we need to be looking at the contract and the scope of work. We need to make sure that the approved work write-up is in there, and that the initial inspection, progress inspections, final inspections were conducted. All that documentation needs to be in there. That we have to be able to show that it's meeting the major systems with the useful life. If their useful life is less than 5 years, that it's replaced, or if you have more stringent requirements, that you're following your more stringent policies. We also need to have, if there were any life-threatening deficiencies that were identified during that inspection, that they are addressed immediately. If you live in an area prone to disasters, floods, fires, hurricanes, that type of thing, that you are providing disaster mitigation within your codes and standards. And then for any pre-78 housing, you need to make sure that you are following the Lead Safe Housing Rule Subpart J for rehab. And you would look at Exhibit 24-1 for Lead Safe Housing Rule Compliance Review. And Les and I are going to be teaching the Lead Safe Housing Rule Subpart J and Subpart K starting next week. So if you have not signed up for that yet, go to the HUD Exchange and you can sign up and learn more about the Lead Safe Housing Rule. So lastly, we're going to talk about procurement and cost reasonableness. So the PJ has to determine that all the home costs are eligible and that they're also reasonable. And so many programs use a bidding process based on the scope of work to ensure that the cost is reasonable. And as part of this bidding process, the PJ typically conducts an internal estimate to establish that the estimate is cost reasonable. So if a PJ is selecting the contractor, they do need to follow 2 CFR 200 for procurement. That starts around 200.317. That's procurement for state. 318 is general procurement standards. 319 is competition. So you want to look in the 300s for procurement. And then if the owner is selecting the contractor, then the federal procurement rules do not apply, but the PJ has to ensure that the costs are still reasonable. And you can look at Exhibits 7-34 and 34-3 for a review of the program requirements for procurement. And then for documentation, we need to make sure that there's a copy of the cost estimate. We're looking to see that it's eligible, that it's reasonable, that there was a review that was done. We want to look at the work write-up. We want to look at the general contractor contract. That's what GC stands for. Any final project budget. We want to make sure that they're being consistent with what we're going to pay for. We want to look at the budget to make sure our home funds are being used for eligible costs. And then if the PJ had to procure the contractor, that they've followed all the federal procurement rules and that they're following the policy, and determination was made that that policy was actually followed. So Les, is there any questions that have come up, or Monty, in the first 2 sections of the requirements?
Yeah, so we have some questions that are relating to loans on these and affordability periods. And so, you know, the key here is that, of course, homeowner rehabilitation doesn't have within the home regulations a requirement for an affordability period. So it's very common, if not normal, for PJs to impose that as part of their program design. And we'll be talking about that a little bit in the second half of this. But my general comment would be, keep in mind that you need to follow what your policies and procedures are that you have adopted, not only covering the HUD regulations, but also your own program design. So things that are your rule, not HUD's rule, you do have the ability to waive, but you need to be consistent, and your policies and procedures would describe that. So we had a question about, you know, I've adopted a 20-year, sounds like a payment term for a loan. Can I reduce that to 10 years? Those things you have the flexibility on but you need to be consistent on that. So we also had questions about using the term recapture or resale provisions. Can they be different? So that's a home buyer provision. So you have the flexibility under homeowner rehab to adopt whatever program design you choose to do. These could all be grants, but generally we see them as some kind of a deferred forgivable loan, or they could be an amortized loan. But that would all be spelled out as part of your program design and then detailed in your policies and procedures, which you then would follow in implementing that. Monty, other things from your list that you think we should raise here?
Yeah, and I just want to reemphasize the point of this program does not trigger resale recapture provisions, as it does not trigger the affordability period. So again, what you define in terms of notes and mortgages and what they pay back, everything else is all a matter of local policy, and I agree with you on that. Another one that I saw that I just want to mention briefly is affirmative marketing came up, a question on that, and the affirmative marketing, Chris covered that, and she mentioned that there are requirements. Make sure you look at 92-351A. There are 5 specific things required in there. The one thing she was not mentioned, it was not on the slide, was that you're supposed to be evaluating the results of your affirmative marketing procedures as well. So working with if it's you running the program or your subrecipients, you should plan to do that on a regular and ongoing basis. And then we get a lot of questions on title, legal ownership, things of that nature. We aren't lawyers and aren't going to answer questions about what is okay. You've got to establish that the occupant, the applicant, has the ownership interest. Ownership on the home buyer side is described simply as fee simple or long-term ground lease. But HUD gave you those 4 other options that Chris went through.
Les, can you still hear Monty?
I cannot.
I don't either.
Monty?
Okay. Monty, we can't hear you.
I'm sorry. I accidentally hit the mute button on with my arm. I just wanted to. I don't know where I cut off, but the other 4 options of ownership under homeowner rehab are there to deal with situations, usually parent and child relationships of one sort or another, where either the current ownership or the future ownership has been conveyed for the benefit of the person that's occupying. Make sure you follow those requirements that are in 92-254C, and if your ownership situation doesn't fit one of those, I would urge you to seek advice from HUD, because you do need to establish home ownership within the regs.
Great, thanks, Monty. Les, anything else before we hand things over to you?
No, I think we can move ahead.
Okay.
Chris is handing off the controls to me, and I'm going to move the slide ahead. And I'm the presenter. Hallelujah. All right. Let me just get set up with a pointer so I can try to be as interactive as Chris is. She's very good with marking things. So we're now going to be covering the administrative requirements as we move along here. All right. So our home subsidy amount. So you probably recall we have minimums and maximums. So the minimum is $1,000, probably not hard to meet in this. But you also then need to be tracking and making sure you're in compliance with the maximum home subsidy. Now, I would think many of you probably have set your program limits lower than that maximum. So whichever of those is more restrictive, but in meeting the home compliance, you're going to have to be able to show that you were tracking and making sure that your program was going to be in compliance with that. Also, you're required to have the subsidy provided in an eligible form. So things that would be included in that would be things like grants, deferred loans, and amortized loans, which is what we typically see as part of this. So for the documentation, you're going to need to show that you've got a work write-up, and then it would be, I think, helpful to have something that shows that you actually did a comparison. So before you signed on the dotted line, is it at least $1,000? Is it within either the maximum home subsidy, or if you have a more restrictive program limit, then making sure that you compare that, and so have documentation on that. And then also keep in mind that over time, you might be executing change orders. So also you would have to watch with change orders to make sure that you still were within those subsidy limits. So typically as part of documentation, we want to see a paper trail that shows that you knew what the requirement was and that you had a process to be able to compare that, as opposed to I accidentally was in compliance, but I wasn't really checking. So looking for some process and documentation as part of that. Your program can provide, it doesn't have to, but it can provide refinancing as part of your homeowner rehabilitation program. So the rules on this, it only can be done when refinancing is going to make that unit more affordable for that household. And really the driving force in this is the rehab, and so the larger costs in this are going to be the rehab versus funds that are being used to refinance existing debt. We don't see a lot of refinancing being done under homeowner rehabilitation, but you can certainly see how that might help to make a unit more affordable. So if you are doing refinancing, then within that documentation would be your review of that project, your determination on how this is going to make it more affordable for that household. We'll mention, I think in another slide or so, that if you're doing that in terms of the loan, that you'd have to underwrite that to make sure that it was going to be affordable for folks. So when you're making a commitment of funds, you need to be able to evaluate each of those projects and have a process you're going to follow through to make sure that all other sources of funding are secured. And so we sometimes see, where perhaps we determine that the needed amount for rehab is $40,000. You have a program limit of $35,000, and you're getting another $5,000 from another local source. We would need to make sure that that was all the sources and uses were in place and have been secured. If you are providing this in the form of an amortized loan, so meaning that they are going to make loan payments, then we need to make sure that this is going to be affordable for folks. So in the case with an amortized loan, then underwriting needs to be done, and that evidence would be part of your commitment requirements that it was going to be affordable based on your policies and procedures as part of that. If we've got other funders, we want to see that we've got written funding commitments, that we're doing a subsidy layering to make sure that we're putting in an appropriate amount. Keep in mind that, of course, environmental review requirements are going to apply as part of this. We also need to make sure that construction is going to start within 12 months. Probably not a big issue with homeowner rehabilitation programs, but that would be part of our evaluation and review in making that commitment. So the documentation that would be in place would be evidence that you've gone through that review of the proposed project. If triggered, also that would include the underwriting review as part of that. So all those sources and uses, your cost analysis on this. If you're doing underwriting, that would be part of that. If there are other funds that are being included in that, then those funding commitments would be part of that file and include your subsidy layering analysis on that. So also evidence of your environmental review process. For a lot of homeowner rehabilitation programs, you might well be doing a program-wide, so you'd be doing a tiered review where there's a program-wide review and release of funds, and then there's a tier 2 checklist that's going to be executed for each individual property. That would be evidence within your files as part of that. And then also a schedule on documenting that that work is going to begin within a 12-month period. We also need to have a written agreement that's in place with the beneficiary. So the PJ would be executing a written agreement with each of the homeowners. And that might be a subrecipient, state recipient that's working on behalf, running the program on behalf of the PJ, but there's going to be a written agreement with each of the homeowners. Those agreements have required provisions. We'll be talking about, I think, on the next slide. And that project has to be set up in IDIS after that written agreement has been fully executed. So the documentation in place, we're going to need to see that written agreement in each file. It would include all the required elements. It would be fully executed. And then to show that we have compliance, we'd need to be able to double check and see that the date that's set up in IDIS occurred after that grant agreement had been fully executed. So just keep in mind that we may have mortgage, promissory notes, mortgages that are going to be executed. Those can be executed later, but it's that written agreement with the homeowner that is the trigger here. We have had programs that that in the past were not meeting this because they simply they got an application from the homeowner and they executed a promissory note and mortgage without having a written agreement. That's not in compliance with this. You need to have an executed written agreement with the required provisions for each of those homeowners. So those required provisions, they're found at 92504 in section C5(2). And so we need to have signatures by both the PJ and the owner. Those will have dates with them. There would be an estimate of the after rehab values, because Chris talked about the fact that we need to make sure that these are going to be modest, and so that's one of our requirements. That written agreement would include language about the principal residency requirements, the amount of assistance that we're providing, the form, the grant, loan, the scope of work. So a lot of times the scope of work would be an attachment to that written agreement. And then the property standards would be called out as part of that. And also the expected completion date would all be part of our written agreement and those required provisions that would be expected to see there. So HUD would likely be pulling some of those written agreements and reviewing them to see that the standard template that you were using did include all the required provisions as part of that. Let's talk a little bit about timelines. So we know that we have a 4-year timeline from the point that we commit funds to getting that project completed. There is the possibility, if HUD approves it, if you request up to a 1-year extension. We don't typically see that under a homeowner rehabilitation program. I would say we're more likely to see projects being completed within 6 months to maybe 12 months at longest. But know that the 4-year project completion rule does apply. The PJ is also required to enter the project completion information within IDIS within 120 days of final project draw. So the compliance review on that would be making sure that the PJ's programs are meeting that 4-year commitment. If they have a 1-year extension in place, then that could go up to a 5-year period. And also double checking that IDIS, that information has been updated within IDIS within 120 days of final draw. That's one of the things that PJs can use some of the IDIS reports to just check the status of files and make sure that they're up to date on getting that information into the system. So record retention, our records are how we're going to show that we followed and met all these requirements, that we followed our policies and procedures. So having those records in place is really important. So records have to be retained for 5 years after project completion. And so in this case, we don't necessarily have an affordability period. In some cases, you may have imposed them. And so that written agreement needs to be in place for 5 years after termination. Files need to be, so our compliance review, seeing that those files are in place, that they are being held for that schedule of time, and that the written agreements are retained 5 years after the agreement terminates. So, a record retention system is necessary to make sure that you're going to meet this requirement. So we're going to take a quick poll here. So when HUD monitors a homeowner rehab project, what documents might it review, and then select all that apply? And the poll is now up, so if you can go ahead and do that and then hit the submit button when you're done with that. All right, the poll has ended, and here are our results. All right, so you were to mark all that apply. So A, the homeowner's application, pay stubs, household size, that's definitely something that needs to be in there because we're documenting that they are an eligible household and collecting a lot of the details. B, the agreement of sale when the homeowner purchased the property originally. Not something we need as part of that. I suppose that could be a local program requirement, but our principal residency is going to be based on a title search that needs to be done as part of that. Chris mentioned that having the deed alone is not going to be adequate. We're going to do a title search and verify that they still own that property. C is something we need, the appraisal or PJ estimate of our homes after rehab value, because you have to have the basis to be able to show that you're within those requirements. And then, of course, environmental review is something that is going to apply. E, we don't have a threshold that the neighbors think that the owner is a responsible homeowner. Thank goodness. That would really complicate things. So the correct answers here are A, C, and D. All right, so we've covered the home requirements themselves, and now we're going to talk about program design considerations. And I guess I would say from years of running homeowner rehab programs, because homeowner rehab has in some ways fewer requirements than some of our other activities. We don't have long-term affordability requirements that the PJ, particularly under homeowner rehab, really needs to think about how do I want my program to operate, who do I particularly want to serve, and so what are my requirements going to be, how am I going to, in a lot of cases you're going to have a lot more demand than you will have funds available. So this becomes a pretty important section for this. So some of the key questions that need to be as part of the PJ's decision on this is thinking about what are we trying to, what's the need that we're trying to address when we address this as part of our consolidated plan, and who are we going to serve at what level, what are we trying to do? So we could be targeting this very specifically to particular neighborhoods and pairing that with other investments. So we might be doing homeowner rehab and doing some infrastructure work using CDBG funds within that neighborhood. or we might be doing this as a citywide or countywide program. So thinking about the targeting, what kind of impact are we looking for, and that would be part of our upfront design. And then thinking about, we've got low-income owners. How are we going to market this program? How are we going to target this? Qualifications can be further restricted. In most cases, we're going to have more, if we're effectively marketing this, we probably are going to have more demand than we have funds available. So, this could be first come, first serve. If that's the case, then is it first application in the door? Is it first complete approved application? In some communities, there's a great deal of demand and they're doing a lottery on this, but you also could choose to make some priorities. And so, maybe we are prioritizing, particular levels of need or particular neighborhoods as part of this, so that we're going to do some kind of rating and ranking as part of this process. Also, as part of that, we'd be thinking about, are you going to have an open window for taking applications? That's usually what's done with first come, first served. Or might you do rounds where you're going to take applications for a period of time, and then all those applications will be rated and ranked, and then you'll work your way through based on those priorities that you've put in place. You also need to make sure that you are appropriately marketing this. And so, Chris mentioned about affirmative marketing on this. We want to make sure that those who are least likely to apply know about that opportunity and have the ability to apply. I have dealt with some communities that had a long waiting list and had not marketed their program in many years and were simply working their way on that list. I'm not sure that that would meet the affirmative marketing requirements on this. And your policies and procedures may need to address things like waiting lists, and will they stay in place and be rolled into the next round, or will you start fresh next time you have funds available to accept applications and follow that process. You also need to think about your operations, who's going to administer that. And as we mentioned in a couple of our sessions, part of monitoring is a really good time to do some evaluation on the PJ's part on how my program is working, where are my risks, where am I experiencing issues. So one of those things is looking at who's actually running the program. It could be run by the PJ themselves. PJ could have a contractor that they've gone through procurement to put in place to run it on their behalf. But we also see a lot of homeowner rehab programs that are being run by state recipients and sub-recipients. And so some evaluation of how that partner is doing, also thinking about when they are done with the program implementation, who's going to hold on to those records? That can be really important, and we've seen some cases where there were some issues about control and access to records after the fact. You also, as part of your program design, could target what kinds of units were going to be included in that. In particular, we also see with manufactured housing, the difficulty sometimes in doing rehab and how much money it makes sense to invest in rehab versus replacement of those units. Those are all things that should be addressed within your policies and procedures. So you have a standard methodology, and it's your justification for saying either yes or no or how much, and making sure that you are consistently dealing with households. So, thinking about how you'll determine the scope of that work, how far, we generally programs are targeting houses that are not so far deteriorated that they still are a good target for rehabilitation. So all of those things are things that the PJ needs to consider and think about and try to capture within its policies and procedures. And then, of course, the amount and form of assistance that we're going to be providing. So we could provide, in this case, we don't have an affordability period. It could be provided in the form of a grant. And we have programs that when the amount of homeowner rehabilitation is low, that they're going ahead and simply keeping this really simple and doing it as a grant. But more commonly, we see these in some kind of a loan with some kind of PJ imposed affordability period. We don't want to spend, let's say, $40,000 in rehabbing a house and then have it sold immediately. And so usually there's some kind of affordability, but that's completely at the discretion of the PJ as part of your program design. So you can put caps in place on what that maximum and minimum. You, of course, have to live within the home requirements, but you certainly can be more specific and more restrictive if you choose. One of the keys on having a successful homeowner rehabilitation project is getting good contractors, and that selection process is really important. So when that contract is executed between the homeowner and the contractor, the owner does not fall under federal procurement requirements, and so you're not strictly held to those requirements, but the PJ always has the requirement of making sure that things are cost reasonable. So in most cases, PJs are going to have something, a bidding process that looks very similar to what we would see, a sort of a simplified version of federal procurement in recruiting or getting bids from contractors and then making that selection. So the policies would need to define how that process is going to go forward, how that decision would be made. Typically, we're seeing that the owner is making that selection, but there's some specific protocol on the basis or how the contractor will be selected, and usually the PJ is going to approve and enforce that. You need, as part of your program design, to think about insurance, and particularly if we're going to provide our funding in the form of a loan. I have seen compliance issues raised in particular by an auditor saying that if we had a lien that was not protected with insurance, that was an issue. So your policies and procedures need to define what your standard will be on insurance. If you're going to require insurance, what your protocol is, being able to document that occurs. And then also thinking about communication, not only with the homeowner, but because we're going to have a contractor involved and we have a specific scope and some timelines as part of that. The PJ is going to be doing inspections as part of that and making sure that the property meets property standards before we consider it to be complete. So thinking about how that communication process will fall in place, and then also how conflict resolution. A lot of PJs have some kind of a conflict resolution policy that is in place, and part of the written agreement with the home owner and also within the contract would require that everyone agree to participate in a dispute resolution process to try to get those resolved as quickly as possible. So one of our key elements of an effective homeowner rehabilitation program is having good rehab standards. So they need to be really detailed and very clear. So, you know, we're trying to make sure we get a good value for the public dollars, but we also want to make sure that we get good materials and good workmanship. And so calling out what the PJ will pay for, any standards that they have in place. In some cases, we might, this is a voluntary program, but we might have some cases where that homeowner needs to temporarily be relocated somewhere else. And that might be that they simply need to be out of the house during certain hours, but it might be that they need to be out for a few days. This is voluntary, so it's not triggering Uniform Relocation Act. And so if the PJ is going to provide optional relocation assistance, that needs to be spelled out in the policy. And that might be saying that, you know, the homeowner is going to be responsible for finding other housing and detailing what costs it would cover. It might be that you have very specifics about we will pay for up to a certain number of days. This is our maximum per day for lodging, what we will pay for food, provision of storage options, all those things being spelled out as part of that. Things that you use to control costs are things like, an internal cost estimate and how that would be used in reviewing bids and when bids would be excluded as not being reasonable. Also things like change order policies, what your process is going to be, who has to sign off. Also retainage. So retainage, for those that are new, is when we're doing rehabilitation, some portion of each draw being held back until the final completion of that project. So you have, essentially, you're holding enough of the contractor's money that you're going to be able to get them to come back and handle those last items before you release that. So all of that needs to be captured within your policies and procedures. In some cases, those are going to be policies and procedures followed by the PJ themselves, but that also may be policies and procedures that you were requiring your state recipient, your subrecipients to follow. That would be detailed within the written agreement you execute with them when you fund them for that local program. So thinking about, the process of inspections, owner approval through the process, we mentioned dispute resolution, and that process for getting the final sign-off on that property. All that needs to be captured within your program design. Let's talk a little bit about preparing for HUD monitoring. So 7-26, which is our CPD monitoring checklist, looks like that. Hopefully you'll familiarize yourself with that. And you'll notice on our slides we've been showing the reference question. So you can go to that form to actually see the actual language on the form. As we mentioned, we're not necessarily covering these in the exact same order that they appear on the checklist to try to make this a little more logical for folks, but we have cross-referenced on the slide the actual question from that. So as part of the process, HUD's going to be assembling some of the documentation. So they probably are going to be asking for policies and procedures and marketing and application information, looking at your written agreements, your rehab standards, citizen input, particularly where we have complaints that are coming in. They oftentimes indicate that there's a problem or there's a pattern of issues that would kind of inform them on what they may want to look at as part of their monitoring. And of course, both the PJ and HUD, as part of their ongoing monitoring, would be looking back at past monitoring findings. So in the past, if they'd identified an issue, part of corrective actions, oftentimes it's going to lay out, we're tweaking our policies or procedures so that we make sure that this doesn't happen again. That follow-up monitoring that would then be looking to see, is this now corrected or is this still an issue? And so, of course, they'll be using Exhibit 7-26 and then pulling the applicable home limits. So the income, the maximum subsidy limit, after rehab value limits would all be things that they would be using. If you were monitoring your state recipients and subrecipients, you would be pulling those items also. And then, of course, HUD's going to look at your open activities report. They're going to be referring back to your con plan and your action plan. What did you say you were going to do with your funds? How was it going to be operated? Who was your target audience on that? So as part of a self-assessment, we've mentioned about the fact that you need to look at the policies and procedures. I would also want to do a quick document review. So, you may have laid out a really good process, implementation process, but unless that file actually reflects that folks are actually following that, you could have some serious compliance issues. So doing a self-assessment, checking those systems, and I would say checking them as early as possible, sort of an ongoing self-assessment would be helpful. And that's certainly what, when you're doing your monitoring of subrecipients, state recipients, you're making sure that they are following your protocols and that the files reflect that. And making sure that the monitoring questions that HUD is going to be using, we have the appropriate documentation. We're going to be in compliance as part of that. So for the pre-monitoring self-assessment, again, policies, procedures, written agreement templates, making sure that you know what the regulatory limits and requirements are as part of that. And then looking to see, what does IDIS reflect? Is that up to date and correctly reflecting what you have in your own files, and a comparison to what did you say you were going to do within your action plan? How is the implementation moving along? Are you on schedule? Are you behind schedule as part of that self-assessment? So looking at your own monitoring process, your own records, whether you have then followed up and responded to not only prior monitorings with HUD, but also with prior monitorings that you've completed with your state or subrecipients as part of that. And then, of course, things like media and citizen complaints. But also, I think it's a good time to take, again, that evaluation of my staff and whether that's in-house or whether that's a partner that's implementing the program, of whether you know, you need additional staff, whether there's additional training. Sometimes that's because you're changing the scope or the, you know, some of your policies or procedures. But there is a self-assessment handout that we've been mentioning as we go along. I would recommend, I think that's a really good starting point as part of a tool, but I think that you need to add to that thinking about your own program design elements and then evaluating whether you're actually following those, whether they're being successfully implemented as part of that. So let's mention resources and tools, and then we'll take a look at questions before we finish up here. So, you know, each time we are highlighting the CPD monitoring handbook exhibits, and in this case, we've been talking today about 7-26. Those are available on both HUD.gov and also the HUD Exchange. And so we do recommend that you familiarize yourself with that. For me, as a former practitioner, I always found looking at those early on and then thinking about, based on the monitoring checklist, what do we need to make sure that we're capturing as we go through the implementation? And so, you know, building checklists and file systems that are going to have all of that required documentation in place, and then checking along the way to make sure that that's actually being effectively implemented. On the HUD Exchange, on the home page, there is a section that's specific to homeowner rehabilitation, and so that would be a spot to go to looking for additional policy guidance, FAQs, other guidance or resources that would be helpful as part of that. And so that could be a useful resource as well. As Chris mentioned early in the training, so in this training, we are specifically talking about the monitoring exhibits and the requirements as part of that. And we're not really teaching in great detail all these requirements. We're making the presumption that you have a good working knowledge of that. So for folks that are newer, if you have not already taken it, the Building Home online training is over 20 hours that you can do at your own pace. Once you complete the initial required sections, you can then pick and choose based on that menu of things that are applicable for the types of projects and the role that you serve. So that would be kind of the first spot to go to learn more on some of these topics that you're realizing as part of this webinar. Gee, I'm not completely sure what some of that is. I need more details. This will be the spot, and the link is provided here on that page. Some very good resources. For those of you that have done the on-site building home trainings over the years, because this is a self-paced online training, in many cases, there's either more current information than you would have heard on site, or we have the luxury of time to go a little bit deeper in some of these topics. So you may want to revisit that. Other tools that are available, Chris mentioned before about the fact that the lead-based paint requirements, lead-safe housing rule, is going to apply on pre-1978 housing. So we've got a link here to learn more about those requirements. Acquisition relocation might potentially apply. Generally, it will not for homeowner rehabilitation, but there's a good link here. The self-assessment tool that we mentioned for PJ doing the self-assessment prior to that HUD monitoring visit. Here's again the link for that. And then there's a handout about property standards, which will be useful for you. As we've mentioned, as we've gone along in these sessions, one of the other resources that you have, PJs do have the ability to request technical assistance. And so there is the link here on this page to request technical assistance from HUD, and that is an option for folks if needed. So before we wrap up and talk about the rest of the schedule for completing this series, Chris and Monty, are there questions that we should revisit?
I will mention a few of them. The issue of records came up a number of times in questions. People were wondering that the 5-year retention pertains to the rehab records from the project being closed out, but several people raised the issue of notes and mortgages that may run out for a period of time, and that's anything that you create in the program, you really need to keep 5 years after completion. So generally, while you could only need to maintain the rehab records for that 5-year period, any note, mortgage, or other legal document that continues to be enforceable should be kept for the enforcement period plus 5 years to allow for a look back and monitoring. Another one that came up was this runs to the PJ sub-recipient relationship and who gets to keep the records. Bear in mind that HUD considers the sub-recipient to be part of your administrative structure. So what they keep and maintain in their office versus what you maintain in yours is between you and them to determine. As the PJ, you are responsible to HUD, and you need to make certain that your sub-recipient is following the rules, so that should be part of your regular monitoring of the sub-recipient, and you will need to make records available to HUD when they come on site to monitor, and you may have to arrange to get those files brought in for that particular event. But again, that is for you to work out with your sub-recipient, but ultimately you are responsible.
And Monty, I would just add to that the sort of additional twist on this is you might have a state recipient or sub-recipient that's hired a contractor who's going to run the program on their behalf. And again, those records are really part of the PJ and the sub-recipients program. And so all of those agreement with contractors and sub-recipients need to call that out within that because we obviously need to maintain access to those records.
Good point. We also had a couple of questions on manufactured housing, and yes, you can rehabilitate manufactured housing that's owned by the homeowner. They can own the unit. They don't have to own the site. They might be in a park or whatever, but they have to own the unit. There are different provisions. There is a home fires on manufactured housing that I would refer you to. One of the questions that came up was about, first of all, the rehabilitation manufactured housing standards. The rehabilitation standards are listed in 92-251E. They run to the HUD installation standards. But also, if some PJs have found it useful or an economically sounder decision to replace the manufactured unit with another manufactured unit, and that is still considered rehabilitation under the definition of reconstruction. Go to 92.2 and read the definition of reconstruction, and you'll see it addressed there. Finally,
okay.
Go ahead.
And I would just add to that I think that's one of the areas where the PJ or its subrecipient will need to have really clear language about what's our decision process on when we will say, no, this is not appropriate for rehabilitation, that this is now eligible for replacement, and having a very clear protocol that is spelled out on that.
Really good point, Les, and that's an important thing to have in policies and procedures, because you don't want that decision to be arbitrary, where somebody gets a new unit and another person gets a little rehab. So it's important to have that kind of standard set up. The go, no-go decision in homeowner rehab is really important across the board. There are times when you'll determine that you just can't go in and fix up a house. It's beyond your ability to repair and the amount of money you can commit and the standards of your program. So you should have the feasibility determination or the go, no-go decision that covers your entire program. So one other thing that has just come up was somebody asked about the 95% value limit. The home ownership value limit for our homeowner rehab programs is to value the property after rehabilitation has occurred, and wondering whether that is, what kind of a standard that is, and whether there's any variation from that. The 95% of area median values of homes sold in the area, 95% of median values sort of puts you in the bottom half of the housing market. When Congress passed the act in 1990, they stated that they were intending to assist housing of modest means, and the Congress imposed the 95% limit. So it's not something that HUD has discretion on. It's a statutory sort of thing. The one thing I will mention is it's a value limit, it's not a cost limit. The maximum subsidy limit is separate from that, and don't confuse those two. It's not restricting the costs, it is restricting you to the lower half of your local housing market.
And I will just mention that as part of that policies and procedures, if you are doing, under rehabilitation, if you are replacing units, reconstruction, whether that's a manufactured unit or you have a homeowner stick-built unit that you determine it would be more effective for you to tear it down and replace it with a new unit, you could choose to have a tiered approach as part of your form of assistance and the term. So because you are putting a new unit in place, you might choose to have a longer affordability period and some different terms on that. So that would all need to be spelled out clearly so it was understandable and that you could show that you were consistently following a set protocol on that. I see we have a number of other questions that seem to be kind of related to the specifics of running a homeowner rehabilitation program. I'm going to suggest that you utilize the online Building Home for that, since our focus today is really on the monitoring exhibits themselves. And it looks like most of these questions are sort of local program design decisions that you need to make and reflect within your policies and procedures. So let's look at the rest of the schedule. So as Chris mentioned, we are in our final week. It's kind of amazing to realize that we have done so many sessions in this series. And so the remaining session will be on Thursday, the 13th, and that's looking at long-term rental compliance. And I believe that's Chris and I think we will have Monty assisting us again on fielding questions. So with that, I think I will bring this session to a close. You get a little bit of time back in your day. We thank you for participating. We hope this has been helpful for you. We really encourage you to use this material and think about the self-assessment so that you will be well prepared for when your HUD monitoring next is scheduled. So with that, thanks everybody, and we'll hope you will join us on Thursday. Thanks.